effect. See there, I told you it was going to record it. All right. If you're going to testify today, I need you to raise your right hand, please.
Do you solemnly swear or affirm the testimony you're giving today is true and correct, so help you God?
I do.
Yes.
Thank you. Put your hand down. Has anybody got a 10:30 hearing or anything? Now, don't lie just for you that I need to get to first. We all good? Okay. All right, cause number 24, the state of Cody Neal Campbell.
Good morning, Your Honor.
Good morning. How are you, ma'am?
Good, how are you? Shawnee Zera here on behalf of Cheryl and Stout, the dependent administrator of the estate.
Okay, you may proceed, ma'am. And I know Mr. Colton's here. On my docket is Adeline for the airship, but I understand we're not doing the airship today.
That's correct. We're not doing the airship at this time.
Okay, you may proceed.
Thank
Is
you.
anyone else here on that hearing?
Yes, Mr. Baker, he's the PI counsel and he'll be testifying as to the settlement.
Good morning, Your Honor.
Good morning. How are you, Mr. Baker?
Very well, thank
All
you.
right, you may proceed, Counselor.
Thank you. We're here on our application for authority to compromise and settle. On October 22nd of 2023, the decedent was tragically killed in a workplace accident, resulting in wrongful death and survival damages in a subsequent civil lawsuit filed under cause number 2023-74111 in the 234th District Court of Harris County. On August 27th of 2024, this court signed the order authorizing Cheryl and Stout as administrator to enter into a contingency fee contract with PI counsel CJ Baker of Armstrong, Lee and Baker to carry the survival claims on behalf of the estate. I have PI counsel here to testify as to the proposed settlement. Mr. Baker, please state your name for the court.
My name is C.J. Baker.
And you are the lead counsel representing the administrator of the estate, Cheryl and Stout, under cause number 2023-74111 in the
Yes.
234th District Court of Harris County, Texas.
Yes, I am.
Okay. And the estate previously approved Ms. Stout's retention of you as counsel on behalf of the estate on or about August 27th, 2024.
Yes.
And you have experience with plaintiff's litigation and personal injury, as well as wrongful death and survival claims.
I do.
Could you briefly talk about the incident that brought about the decedent's death?
Cody was an electrician working in the oil field in West Texas. He was killed in an arc fire explosion. At the time of the explosion, he was working in a small cabinet similar to the size, for instance, of a under-counter dishwasher. The arc was fueled by 5,000 volts of electricity, and the explosion forced his body against the inside of the cabinet, shattering his skull and killing him immediately.
Okay. And on June 18th of 2025, the parties attended mediation in order to attend settlement prior to moving forward with trial.
Correct.
Your Honor, at this time, I would like the court to take judicial notice of the proposed settlement agreement that was previously submitted to the court in camera.
Take judicial notice that I have a copy of it here in front of me.
Thank you. And pursuant to the proposed settlement dated June 18, 2025, the estate is receiving gross settlement proceeds of $200,000. Is that correct?
Correct.
And now let's talk a little bit about the expenses coming out of the gross proceeds. So pursuant to your contingency fee contract approved by this court, your firm is entitled to receive 40% of any settlement after the lawsuit is filed, but before trial begins.
That's correct.
And this contingency fee structure is standard in personal injury claims. Is that correct?
It is.
So your firm, out of the $200,000, receives $80,000 for representation in this matter.
That's correct.
Now the parties, namely Ms. Stout, also in her individual capacity, Tatum Pounds and Avery Campbell have agreed to absorb pro rata the cost of all litigation expenses incurred in the wrongful death and survival lawsuit in this estate.
Correct. The costs of the litigation are being borne by my other clients.
Okay, so other than the child support lien in the amount of $19,730.47, there are no other expenses that are being tagged against this estate.
Nothing arising from the case.
Okay. And thus the net proceeds of the settlement to the estate come to $100,269.53.
That's correct.
And the settlement that we are requesting this court approve today fully and finally settles against all named defendants on behalf of the estate.
Yes.
And this proposed settlement fully and finally disposes of the estate's interest in the litigation. Is that correct?
Correct.
And the funds being paid to the estate also serve as consideration for a release of the estate in the settlement agreement.
Yes.
The settlement agreement will be distributed according to the intestacy laws of the state of Texas when we do a heirship proceeding.
Correct.
Okay. And you believe that this settlement is in the best interest of the estate?
I do.
I pass the witness, Your Honor.
No questions, Counselor?
All right, Your Honor, that's all that I have. We would, given that the net proceeds of the settlement coming to the estate is a little over $100,269.53 to be exact, we are requesting that the court increase Ms. Stout's bond to at least that amount, since there are no other assets of the estate. Currently, she only has a $50 cash bond.
All right, so I'm gonna order the authorizing the compromise and settlement authorization for release of funds and increase the bond amount to let's do $101,000.
Okay.
Covered all. And attorney's fees.
We are just here on the application to approve the settlement agreement. We will file the attorney's fees at a later time.
Okay, so I have an application to pay attorney's fees. We're not hearing that this morning.
No, Your Honor.
Okay. Yeah, anything else come before the court?
Nope, that's going to be it.
All right, thank you all. Have a good day.
Thank you.
Thank you,
too.
Judge.
All right, call number 81, the state of Marissa Kama. Mr. Fuller, good morning.
Good morning, Judge. We're present. I have
Scott.
2 witnesses.
Thank you. You may proceed.
All right, Ms. Kalma, would you state your name for the court?
Patty Lynn Kalma.
And you are the mother of the proposed ward, Marissa Kalma, is that correct?
Yes.
She's a female born on July the 26th, 2007. Is that also correct?
Yes.
And she presently resides with you and your husband at 3315 Kathleen Drive in Baytown, Chambers County, Texas.
Yes.
And you are her mother, and you're here with the father, Kirk Kalma, is that correct?
Yes.
Your daughter is incapacitated, is she not?
Yes.
Would you briefly describe to the court the nature and the degree of that incapacity?
Yes. Marissa was born with HIE, hypoxic ischemic encephalopathy. She lost oxygen to her brain at birth, and she currently is a spastic quadriplegic with cerebral palsy and seizure disorder, and she is nonverbal and wheelchair bound.
We have considered any other alternate or other options as far as avoiding the guardianship as an alternative, and we found nothing that would be feasible in your daughter's case. Is that correct?
Yes.
And obviously, she's not able to operate a motor vehicle or make personal decisions in regards to her residency.
Yes.
Your Honor, a court medical narrative by Dr. Aaron Miller has been filed with the court, and I'd ask the court to take judicial notice or would offer that into evidence at this time.
I have no objection, Judge. I've reviewed it also.
Thank you, Counselor.
Ms. Kalma, you and your husband have completed the required guardianship course, have you not?
Yes.
You both are qualified to serve as guardians, are you not?
Yes.
And you believe it is in your daughter's best interest.
Yes.
And you also recognize going forward that you'll have certain obligations in regards to the guardianship, such as providing an annual report in regards to her status.
Yes.
And that she is, under the definition under the estate code, totally incapacitated, is she not?
Yes.
Your Honor, I would pass the witness.
Yes.
Yes, Judge. Ms. Kalma, we visited in the afternoon a couple of weeks ago. Saw your daughter and visited your home, and nothing has changed in her status since that time, has it?
No, it has not.
Okay. Well, as a parent, I appreciate what you're doing and appreciate what you've done.
Thank you.
Judge, I have no further questions.
Thank you, Mr. Fuller.
Your Honor, I'd like to call Mr. Kalma, if I may.
You may proceed.
Mr. Kalma, would you state your name for the court?
Kurt Moran Kalma?
And you're the father of Marisa Kalma, are you not?
Yes.
And you support this application for appointment of guardian of the person of your daughter, Marisa Kalma?
Yes.
And there's no reason to your knowledge why you'd be disqualified?
Correct.
And you're asking the court to appoint both you and your wife, Patty Kalma, as co-guardians of the person?
Yes.
Pass the witness, Your Honor.
Mr. Cotton.
Judge, I have no questions of this witness.
Thank you, Mr. Fuller.
Your Honor, that's all we have.
All right, so this is for appointment of the guardian of the person only?
Just of the person, Your Honor. We'd ask it be a minimum cash bond.
Okay, and I'm gonna approve the guardian of the person and make a $20 cash bond. And I see Mr. Cotton's headline fees of $700. I'm also gonna approve that. And I think that covers it.
Thank you, Your Honor.
Thank you all. Have a good day.
Thank you, Judge.
Thank you, Judge. We excused?
You are.
Thank you.
All right, cause number 85, say to Ronald Lee Merle. Mr. Kyle, good morning.
Good morning, Judge.
You may proceed.
Thank you, Your Honor. Your name is Sherry Porras, is that correct?
Yes, sir.
And your father was Ronald Lee Merle?
Yes, sir.
He passed away on April the 7th of this year,
Yes, sir.
and he had his fixed place of residence in Winnie, Chambers County, Texas on the date of his death?
Yes, sir.
Okay. And he left a valid written will dated September 10th of 2024, is that correct?
Yes, sir.
And you have a copy of that will? And
Yes, sir,
and
we do.
you recognize that to be the original of his last will and testament?
Yes, sir.
And you recognize his signature on that will?
Yes, sir.
And so far as you know, he never amended or revoked that will?
No, sir.
And he didn't leave anything to any governmental agency or charity or anything like that?
No, sir.
He had no children born to or adopted to him after the date of the will?
No, sir.
He didn't get divorced after the date of the will?
No, sir.
And the will named you to be the independent executor of his estate?
Yes, sir.
And you're not disqualified in any way because you're not a felon or anything like that?
No, sir.
Okay. And you're here today asking that the court approve your application to admit his will to probate and name you as the independent executor?
Yes, sir.
Okay. That's all I have, Your Honor.
You're done. Thank you, Counselor. I'm gonna tell you those Merle boys are character.
Really?
Always have been.
I know. All right, thank you.
Thank you, Judge.
Cause number 90, the state of Edward J. Richmond.
That
Mr.
would
Mayo,
be-
good morning.
Good morning.
And you may proceed.
All right. My name is Colton Wade Mayo, and we have Edward I. Richmond, aka Edward Richmond, passed on March 31st, 2025 in Beach City, Chambers County, Texas, at the age of 76. So 4 years have not elapsed since his date of death. He had a residence and fixed place of residence and domicile in Chambers County, Texas. And on August 15th, we filed what I know to be his last will and testament. And to my knowledge, it was never revoked. That will is dated December 13th of 2018. A necessity exists for the administration of the estate. No children were born to or adopted by him after the execution of this will. No marriage of the decedent was ever dissolved. The will does not name the state of Texas, an agency of the state, or a charitable organization as a devotee. And we have Cynthia Joyce Richmond, executor named in his will, and she's not a convicted felon, and she is qualified and not disqualified from accepting letters testamentary and entitled to receive letters testamentary. And we ask that she be appointed as independent executor without bond. We ask for waiver of an appraisal, and it's a non-taxable estate, Your Honor.
Well, thank you, Counselor. All right, cause number 93, the state of Janet Shamblin Mullins.
Well, you're not rid of me yet.
I know, and you may proceed on it.
All right. My name is Colton Wade Mayo, and I have personal knowledge of the facts. Our decedent, Janet Shamblin Mullins, died on June 30th, 2025 in Baytown, Harris County, Texas, at the age of 79. Therefore, 4 years have not elapsed since the date of her death. She was a resident and domiciled and had a fixed place of residence in Chambers County, Texas. And the document we filed also on August 15th of this year is known to me to be her original last will and testament dated July 12th, 2015, excuse me. And to the best of my knowledge, it was never revoked. A necessity exists for the administration of the estate. No children were born to or adopted by her after the execution of the will, and no marriage of hers was ever dissolved. Her will does not name the state of Texas, an agency of the state, or a charitable organization as a devotee. And she named Terry Wayne Mullins and Richard Blake Mullins as co-executors in her will. Neither of them are convicted felons, and both of them are qualified and not disqualified from accepting letters testamentary and are entitled to receive letters. So we ask the court to please appoint Terrell Wayne Mullins and Richard Blake Mullins as independent co-executors without bond. We ask that you please waive appraisers as it's a non-taxable estate.
Well done. Thank you, Counselor.
Thank you very much.
Have a good day. Where's your daddy? Off hunting somewhere?
He's about to be.
Yeah, I figured. It's that time of year.
Next week he goes to Canada for geese. So
Yeah, I knew his Canada thing. Take care. Tell him hello.
bye.
Hi, call number 95, the state of Robert Edward Merriman.
Good morning, Your Honor.
Good morning. You don't look like you've had much sleep.
I just had a newborn last week. So,
I know. That's what Christy was telling me. So
yeah, it's been hard. It's been hard.
yeah, sir. I understand.
I'm adjusting to it.
It's been a while for me, but I do remember. So you may proceed.
Yes.
You may
Your Honor,
proceed, Counselor.
We're applying for immuniment of title for the will to be admitted for Robert Edward Merriman. I have Allison Merriman here, and she's the beneficiary of the will. Please state your name.
Allison Merriman.
Were you legally married to Robert Edward Merriman at the time of the death?
Yes.
I am presenting you with this document. Do you recognize it? And do you state it's the true and correct copy of Robert's last will and testament?
Yes, it is.
Is that Robert's true signature?
Yes, it is.
Was the will executed according to Texas law, being signed by a testator and two witnesses?
Yes.
To your knowledge, was this will ever revoked, replaced, or altered by Robert?
No.
To your knowledge, is there anyone that may be contesting this will?
No.
Who are the beneficiaries on this will?
Myself, I am the sole beneficiary, Allison Merriman.
Did the descendant own real property in the state of Texas at the time of his death?
Yes.
What was the address of the property?
9743 Bayou Woods Drive, Baytown, Texas, 77521.
Thank you. Did Robert pass away on June 3rd, 2024 in Chambers County, Texas at the age of 69?
Yes.
At the time of his death, was Chambers County, Texas, Robert's permanent resident and domicile?
Yes.
Since April 20th, 2022, when this will was created, were there any children born or adopted by Robert since then?
No.
Since that date, was your marriage to Robert ever dissolved or divorced?
No.
Since that date, to your knowledge, are there any debts owed to the estate that would require administration?
No.
Are there any other claims expected to be filed against the estate?
No.
Your Honor, we respectfully request that Robert Edward Merriman's will be admitted to probate as a muniment of title, and there shall be no administration of the estate as necessary.
So done. Thank you, Counselor. Good luck with the new baby and congratulations.
Thank you, Your Honor. I appreciate it.
Take care. Have a good day.
Okay, take care.